lost 5-4. Talk about your response to the decision, Jamil.
Sure. Well, obviously it's a very disappointing decision, and in some ways the fact that it was 5-4 makes it even more disappointing. It's a challenge to, as you said, the Foreign Intelligence Surveillance Act, and specifically to the amendments that were made in 2008. And those amendments essentially allow the National Security Agency to engage in dragnet surveillance of Americans' international communications. So it's a very broad surveillance statute.
The National Security Agency
engages in
larger than the CIA.
Larger than the CIA, and it engages in signals intelligence gathering by monitoring phone calls, monitoring emails, monitoring other electronic communications. It's a massive agency that has incredibly sophisticated surveillance authority now. And that agency uses this particular statute, the Foreign Intelligence Surveillance Act, to, among other things, gather Americans' international communications, communications between people here in the United States and people outside the United States. So it's a very broad surveillance statute, arguably broader than any surveillance statute that Congress has sanctioned in the past. And we brought a challenge to it right after it was passed. This was actually built on an earlier challenge to the warrantless wiretapping program, which is the program that President Bush inaugurated right after 9/11. So right after 9/11, the National Security Agency was told, you no longer have to seek warrants from federal judges in order to engage in surveillance of Americans' international communications. You can do this on your own without the involvement of federal judges. That was against the law. It was against the Foreign Intelligence Surveillance Act as it was written at the time, and it was against the Fourth Amendment of to the Constitution. And we had challenged that. We had challenged it in a case called ACLU versus NSA. The Center for Constitutional Rights had also challenged it in a separate case. Those cases wound their way through the system. Eventually, the government retired the warrantless wiretapping program, went back to Congress and said, you need to change the law to make it legal to do everything that we have previously been doing illegally. And some of us naively thought that Congress would reject that proposal. Some of us even naively thought that there would be serious investigations into what was criminal behavior, the violation of the Foreign Intelligence Surveillance Act. Instead, what Congress did in 2008 is pass this broad law, the Amendments Act, which not only codified the power that President Bush had previously been exercising, but expanded the power of the National Security Agency to engage in this kind of surveillance. And again, now the surveillance is not individualized. It's not targeted at people who are thought to be engaged in terrorism. It's dragnet surveillance. That's what the new law allows. Surveillance of hundreds or thousands or even theoretically millions of people who might not be suspected at all of having done anything wrong. So that's the law we challenged in 2008. And the decision yesterday was effectively a decision holding that we don't have the right to challenge the law.
So could you explain, Jamil Jaffer, the grounds on which the decision was taken yesterday, the basis, standing grounds, and what it means for a likely future judicial review of the amendment?
Right. I mean, so when we brought the case, our claims were constitutional claims. We argued that the statute violated the First Amendment because it imposed a burden on expressive and associational activity without sufficient reason. We argued that it violated the Fourth Amendment, which generally requires warrants before the government engages in this kind of surveillance. Those were the arguments we made in the district court. But the government came back and said the court shouldn't reach those arguments at all. The court shouldn't consider whether the law is constitutional or not because the ACLU's plaintiffs can't show that they themselves have been monitored under this law. And of course, nobody can show that they've been monitored under the law because the government doesn't disclose who its targets are.
Which is sort of why you're challenging it.
Right. I mean, that's part of the challenge. And the government is sort of creating this hurdle that is insuperable, this barrier to judicial review, which will ensure that nobody can ever challenge this kind of statute in court. And they were successful at the district court. We then appealed to the Second Circuit in New York, and we prevailed in the Second Circuit. It was a 3-0 decision in our favor. The government then asked the Supreme Court to hear the case, and yesterday's 5-4 decision against us is the result.